Welcome to Ethics and the IP Attorney, Serving Two Masters by Quimbee. My name is Ken Kula. Paradoxically, intellectual property law is both the same as any other type of law, family law, criminal law, contract law, and different from any other type of law. It is the same in the sense that every IP attorney who litigates must adhere to the ethical rules of the state in which he or she practices. Those rules most likely mirror the model rules of professional conduct put forth by the American Bar Association as adopted by the various states. Intellectual property law, however, is also different from the other areas of the law. That is because IP attorneys typically practice before the United States Patent and Trademark Office, which I'll refer to as the USPTO. That office's personnel will unabashedly tell anyone who asks that they, quote, take very seriously the competency and conduct of attorneys who practice before the USPTO. All attorneys who practice before us are subject to our disciplinary jurisdiction and must abide by the USPTO rules of professional conduct, period, end quote. That comes from the website www.uspto.gov under Hiring a U.S. Licensed Attorney. This presentation strives to ensure all participants gain a general understanding of the ethical issues that may affect IP attorneys. To do so, the presentation includes a number of course materials, including today's slides, complete with detailed presenter notes, current articles on ethics or intellectual property law, and 5 cases that address ethics and the IP attorney in specific aspects of the law. You may follow along with those slides or simply sit back and enjoy our presentation on ethics and the IP attorney. In the end, it will provide you with a unique overview on ethics as it relates to intellectual property law, including an analysis of cases and USPTO ethical rules that address areas that are rarely discussed in other CLE programs. The cases and their specific topics that we will be discussed are the following. 1. Advanced Manufacturing Technologies, Inc. versus Motorola, Inc. And it's a District of Arizona case from 2002, and it will discuss the inadvertent forming of the attorney-client relationship. Second, we will talk about Freeman Equipment, Inc. versus Caterpillar, Inc. It comes from the Northern District of Illinois Federal Court at 262 Fed Sup 3rd, 631, and it discusses whether the past representation of an alleged infringer by the patentee's current counsel warrants that counsel's disqualification. We'll also talk about CLE versus Original Media Group, a slip opinion that came out in 2020 and is found at 2020 Westlaw 136659. And it raises the possibility of an ethical violation by an attorney who fails to cite controlling authority to the court. It also discusses other information about how an attorney should present his or her case to the court. We will also talk about Bel Air Electronics, Inc. versus Carved, LLC, another slip opinion that came out in 2021, May 7th, 2021, out of the Northern District of Indiana. And it discusses both the proper and improper use of Rule 11 of the Federal Rules of Civil Procedure in a patent infringement case.